ladies and gentlemen. I'm the chair of this last session. It's a session that is important for us. It's the, we call it the Caspar Bowden session. He's a privacy activist and a practitioner of the first generation, very instrumental in setting up this conference and also the PETS conference in Leuven, a man with a great vision about business, governments, and academics meeting each other. He passed away not so long ago, and that's why we honor his vision by dedicating a special panel with his name included in it. And his attention went to a lot of things, but he was always very critical for governmental initiatives. He was also always questioning the good faith of, no, not the good faith, but testing out intentions and checking whether the arguments advanced by policymakers were solid. So he was a man of arguments and a man of checking and testing arguments thoroughly. Nobody really liked to be questioned by him, but everybody saw him as a very fair person. And so after 3 days of intensive debating, this last panel dedicated to Caspar Bowden will nicely bring some closure, I hope, for this year. I'm the chair. I'm not going to do anything. I have the privilege of having Giovanni Butterelli, the supervisor, European Data Protection Supervisor, as the moderator. And I feel, as every year, I feel very confident that he will take care of this interesting group of speakers and the difficult, sensitive topics that are on the agenda, and allow me to sit back and enjoy and learn. Please, Giovanni.
Thank you, Paul. Good evening to everybody. I think Caspar would be very delighted to be here for such a political panel. A couple of seconds to frame and understand why we're here, why we dedicate such a political panel to encryption in a moment where the European Commission is approaching an initiative on e-evidence. For a long time, encryption of communication has been implemented as a means to keeping communication secure and confidential. And new and advanced technologies offer both an encryption opportunities, but also possibilities to break and circumvent encryption. And therefore, on the legal side, there is a heated debate on as to how governments could legally gain access to people's electronic communications with as few hurdles as possible. And this debate has gained prominence with the recent terrorist attacks. So thus encryption has become a multi-faceted concept, which is seen both as preserving the confidentiality of communication as a pivotal element of privacy and data protection, but at the same time as a potential limitation of security. We have identified a lot of questions for today's panelists. Among them, let me focus on at least 3 of them. First of all, what are the data protection requirements on interference with the confidentiality of communication? Secondly, in how far is encryption a hindrance for the work of the law enforcement authorities? And finally, how can we legally and also technically achieve secure and confidential communication without putting the work of the law enforcement authorities at a disadvantage? In doing that, I will not refer to what the EDPS did. Let me simply say that we intervene on this issue at regular stages. For instance, we adopted some comments on the cybersecurity package. You will see from our website that we welcome the Commission, the European Commission, when it emphasizes the need to develop, let me quote the European Commission, encryption capabilities as essential features to protect information and fundamental rights. And we also welcome the fact that the Commission plans to propose a range of measures to support member states' authorities in tackling encryption in criminal investigation without, I'm going to quote again the Commission, without prohibiting, limiting or weakening encryption. But of course, we also note that the Commission plans to propose legal measures to facilitate access to encrypted evidence, and also technical measures to enhance decryption capabilities. And therefore, we consider that all these measures were proposed must be implemented in full respect of fundamental rights, observing the principle of proportionality. And if you would like to also go deeper, have a look to our recent opinion on the privacy regulation, where we started speaking about a sort of a right to encryption. Users, in our view, should be allowed to use end-to-end encryption without backdoors to protect their electronic communications. And in our viewpoint, that's a message, a recommendation for the ongoing trilogue, should specifically prohibit encryption providers, communication service providers, and all other organizations at all levels of the supply chain from allowing or facilitating backdoors. As moderator, we'll go immediately to the substance. I will introduce one by one the distinguished experts. I will start with Xavier Tracol, well-known senior legal officer at Eurojust since September 2008. He works in the data protection service. He participates in different committees of Eurojust. He's a member of the professional board of the Computer Law and Security Review. Many articles to be quoted. So, Xavier, let me now go back to the questions. I know that you have a presentation, but we would like to ask you in particular, in your view, to what extent are the political demands for breaking encryption really justified by the needs of law enforcement? And also, as you're working at the interface between technology and the law, how do you see the interaction between legal and technical means to protect the fundamental rights to privacy? I'm quite confident that in the specific presentation you are going now to share with us, there are interesting thoughts for us. Perhaps it's better you do it from here, or are you? Your choice.
Good afternoon, everyone. As Giovanni said, I'm a senior legal officer working at Eurojust. So, first of all, I think to make sure that we are talking about the same thing, we should start with a definition of encryption. I'm using the definition which was provided by the Information Commissioner's Office, which is that encryption is a mathematical function using a secret value, which is the key, which encodes data so that only users with access to that key can read the information. Now, this definition is accurate to the extent that we're talking about symmetric encryption, since it refers to a single key. However, you also have another type of encryption, which is called asymmetric encryption, in which you're using two different keys. One key to encrypt the data and a different key to decrypt it, which is not foreseen in the definition of the ICO. Now, what is the purpose of encryption? Encryption is of fundamental importance because this is one of the few effective technical tools which are available to ensure the respect for private life and the protection of personal data against interference with the confidentiality of electronic communications. It was looked at by the Article 29 Working Party, which stated that strong and secure encryption is a security practice which aims to provide the confidentiality of a communication channel between identified parties to avoid eavesdropping or unintended disclosure. It was also considered by Parliament in a very comprehensive resolution which was adopted in the context of the Commission decision on safe harbor. And in this resolution, Parliament called for the promotion of the wide use of encryption of content to reduce the risk, the level of risk that US authorities, including the National Security Agency, may access the data on a generalized basis. We're talking here about encryption of contents only. This resolution does not refer to the encryption of metadata, although of course, technically, it is also possible to encrypt metadata. Any data can be encrypted, just like content data. Now, specifically, my presentation will focus today on the first question which was asked to this panel, which is the data protection requirements on interference with the confidentiality of communications. And more specifically, my presentation will focus on the case law of the Court of Justice of the EU, since it considered this issue in depth. The first point is that the two fundamental rights to respect for private life and to the protection of personal data are not absolute rights. So meaning, to be more concrete, that they may be limited. The digital rights judgment is the landmark decision in which the Court of Justice invalidated the Data Retention Directive. And the Grand Chamber in this decision first examined whether there was any interference and then considered whether the interference was justified. So this is the reasoning and the methodology which was used by the Grand Chamber. And by the way, this is exactly the same reasoning and methodology which are used by the European Court of Human Rights, which is, as you probably know, a different court which is located in Strasbourg. So these methodology and reasoning are aligned between these two European courts, which is, of course, of fundamental importance. So in these judgments, the court first considered whether there was an interference, first step of the reasoning with the two rights, and it found that there were two separate interferences with the right to respect for private life. One was because the data was retained, and distinct interference, there was access of competent authorities to the data. It also held that there was an interference with the right to protection of personal data, and in addition, that all these interferences were both wide-ranging and particularly serious. Now, second step of the reasoning was the interference justified or not? And the answer to this question is based on Article 52 of the Charter of Fundamental Rights. The requirements are that the limitations to the fundamental rights must be provided for by law. They must respect the essence of the rights, and the limitations must be generally necessary to meet objectives of general importance. The first requirement is not so controversial, so I will not talk about it. I will focus on the second requirement of respect for the essence of the rights, which is more interesting. If you have access to the contents of the electronic communications, this compromises the essence of the fundamental right to respect for private life. This is what the court considered. Therefore, there is no need for the court to get into whether the test of proportionality is met or not. The simple fact that there is access to the contents of the data is sufficient for an essence of a breach of the essence of this fundamental right. The third requirement concerns the principle of proportionality and strict necessity. And here, the seriousness of the interference implies that the retention of communications data and access to this data should be restricted to serious crime. So this possibility is limited to serious crime very clearly, and domestic legislation of member states must require a relationship between the retained data and serious crime, or at least a threat to public authority. In addition, you need targeted retention of data. Now, what is meant by that? It means that the domestic legislation must be limited either geographically or temporally, or in terms of persons who are targeted. So you must deal with, suspects basically of serious crime, always these requirements. Now, regarding the level of protection of fundamental rights and freedoms, which is guaranteed within the EU, here are two cumulative requirements. First, you need clear and precise rules. It cannot be left to the discretion of member states. And second, a connection must be established between the data and the objective which is pursued. So those are the main data protection requirements which have been established by the Court of Justice. I did not go into all the details. Now, moving on to the other questions asked to the panel. In how far is encryption a hindrance for the work of the law enforcement authorities? I would say yes, of course, and encryption prevents law enforcement authorities from accessing the data, so it is therefore clearly a hindrance for the work of law enforcement authorities. Now, law enforcement authorities also use strong and secure encryption themselves in their work. For instance, at Eurojust, where I work, we use a strongly encrypted email system, and we also have an encrypted case management system, which is the IT system that we use in order to process all the personal data related to data subjects. How can we legally and technically achieve secure and confidential communications without putting the work of the law enforcement authorities at a disadvantage? Well, clearly law enforcement authorities cannot access encrypted data, so they have to use other measures in order to investigate the cases. These measures include covert surveillance, wiretapping, and house searches. Now, the paradox of the situation is, of course, that this measure may be more intrusive in practice than access to confidential communications and especially metadata, and even more if we're talking about the content of data, of course. Now, last questions, and trying to move quickly. What other fundamental rights could be impacted by breaches of encryption? Here I'm going back to the case law of the Court of Justice, where it's clearly said that the individual freedom of expression may be impacted. It was a theoretical finding in the digital rights judgment, much more practical in the Tele2 judgment. Now, interestingly, from a procedural point of view, it's a plea which was raised ex officio by the Grand Chamber, which is quite a rare thing, and which gives a hint about the importance which is granted by the Court of Justice to individual freedom of expression. Now, let me simply finish by referring to the keynote speech of the EDPS at the French National Assembly on the 21st of November 2016, where Giovanni said that no persuasive evidence is available that any restrictions on encryption are effective enough to justify the interference with fundamental rights and freedoms that they would cause. Ladies and gentlemen, I could not agree more with the statement of Giovanni. I thank you for your attention, and I remain, of course, available for any questions that you may have.
Well, thank you, Xavier, for such an exhaustive and complete summary of the legal framework. It may help the panel while answering at the same time carefully to some of the questions. Now it's time to move to Bart Prinel from KU Leuven. He's a full professor at that university where he heads the IMEC COSIC research group with 80 members. You have been author of numerous scientific publications. You are an inventor of 5 patents, and I think you are the only one here who developed an encryption tool, isn't it? So in addition to the awards mentioned in your impressive CV, I think you can now, let's say, share with us your assessment. In particular, my question is, in your view, is it technically possible to design encryption tools which allow access to law enforcement but not to one else? And again, what are the risks in general when we weaken encryption for economy, society, and even law enforcement bodies, since Eurojust as well uses encrypted messages. But the floor is yours. You can even speak from there as you wish. Okay.
Thank you very much, and it's a great honor to try to follow in the steps of Caspar. I hope I can achieve only 10% of his ability to speak about policy and technology together. So I chose a very provocative title. Law enforcement access to encrypted data is technically possible, because if you use Signal or WhatsApp, you can actually have group chats. So you have Alice and Bob talking, and there can also be a third person and a fourth person. So the NSA can be listening, and GCHQ, and the police force. Anybody can join all our secure chats, right? Technically, it's perfectly possible to have an encrypted chat where all your friends and your non-friends join the conversation. So what, of course, computer scientists have been saying is the opposite. Law enforcement access to encrypted data is technically impossible without undermining the security of society. And we've been repeating this over and over. This is a very old debate. In the early 90s already, we had this debate. But for some reason, there seems to be a clash of cultures. So computer scientists or cryptographers, we try to determine what's possible and not possible. But politicians and lawyers, they try to find a balance or a compromise. But unfortunately, as a computer scientist, I don't see where the compromise is. And if we don't understand this, I'm afraid that we'll have another panel in 10 years about the same topic with the same discussion. So we should try to make progress. So as I mentioned, it's so 90s, right? I was living in Berkeley, in California, when Clinton proposed the Clipper chip, and you can see here the telephone for which it was intended, and this was exactly the same debate. The US government wanted access to communications, and they wanted to get access to the keys in a unique way, and as you may know, the Clipper chip was defeated. So I think an interesting question is, we're now 24 years later, do we actually have secure communications? And of course, in particular, after Snowden, the industry has stepped up, and we have now end-to-end encryption in Signal, in WhatsApp, in iMessage, and so on. But if you place a call on this telephone, it's not encrypted end-to-end. Not in 2G, not in 3G, not in 4G, and probably not in 5G either. Okay? So this morning there was a panel in which a lawyer was complaining that the Dutch intelligence services were listening to conversations between his clients and himself. Well, he was using his phone probably, and he didn't have end-to-end encryption. So in society, we don't seem to have end-to-end encryption. Our telephone system is based on SS7, and SS7 is completely insecure. The most difficult part is to somehow buy access, buy a seat on the system, and once you're in there, it's completely open. And you have full control over the complete telephone system. We also had a workshop earlier this week on crypto and policies, and it was very interesting because Europol explained their concerns, and I guess you can imagine the areas for which they have concern: child pornography, drugs, and terrorism. But also they made a statement that they were more concerned about stored data than about communicated data. And I guess you have the Apple versus FBI is a good example of this. But of course, all the data we have stored in the cloud. And I'm not going to name you particular vendors, but even many vendors who advertise widely popular end-to-end encryption keep a backup copy of your messages in the clear. Just in case your phone dies, you can actually buy a new phone, log in, and find all your messages back. And unfortunately, that's only possible if they have a copy in the clear. And then we know from Snowden that if there is a copy in the clear, your data ends up with the NSA. So I think it's a good question to ask, do we have today end-to-end secure communication? By the way, you can, in some tools, you can switch off this option, and you can trade security for convenience. Already touched by the previous speaker, what about the metadata? And I do understand that from a legal point of view, there is a difference. There is a big difference between content and metadata. But I do have bad news. Metadata is data. In most cases, metadata is extremely meaningful. If it's a medical website, the metadata will tell you which diseases you were looking for. So this idea of we can separate content and metadata, this worked in the phone days, but this no longer works. Plus, there is a lot of more metadata, which is, for example, fingerprinting of browsers or devices, which is actually not even considered in the current definitions to be metadata. So I think if we want to protect communications, we also have to protect the metadata. So law enforcement complains they don't have access to the content. I think today they have much more metadata than they ever had before. If you have a modern car, it actually reports to probably your garage owner, probably to Mercedes or BMW, and probably also to other people where it is at any time. This is information law enforcement has been using in the past and in recent times, and they will actually not tell you about these new features they never had in the past. So metadata has made investigations harder. Of course, they do argue that in court they want to show the content, and as we heard in the previous talk, that if we can't get the content, we'll use even more intrusive methods. This is more or less where we are. Of course, the intrusive methods they have been using as well. I mean, in the past we also had opening of mail, entering houses. Those things have always existed. So I think an interesting question is also, who is law enforcement? Is it the local police force of Brussels? Is it the national police? Is it Europol? Or is it also intelligence? Because as soon as you go to things as terrorism, I think the boundaries between intelligence and law enforcement start blurring, and we actually don't know where these things go. And if you say law enforcement, it's a very broad definition. You can also ask, is it law enforcement of our own country? Or is it the EU countries? Is it the NATO countries? Is it the friendly countries? Or is it also countries that actually violate human rights on a consistent basis? Do the law enforcement there also get access to the same key? I think it's a very important question. And the other question is, if we let in law enforcement, this is the point why it's impossible, if you have access to law enforcement, you also have access to bad guys for any definition of bad. What is your definition of bad guys? Well, they will also get in some way access. It's almost impossible to stop this, and this is the core objection why we think it's not good to have a backdoor. And anyway, if you had a backdoor, who are the bad guys who would use systems with backdoors? Now that you can use actually Signal or Telegram, why would you use a system with backdoors anyway? So Europe has understood this, and I was very pleased to see, as alluded by our chair, last September there was a communication in which Europe said we want strong encryption, we don't want to weaken encryption, we're against backdoors, we're against measures that weaken encryption for everybody. So this is the good part. Then if you read on, but Europol will get 96 extra people to decrypt communications, to break encryption, and to develop a toolbox. Also, the countries are encouraged to work on a toolbox to actually break encryption. So I think, as a citizen, I have the right to know what would be in such a toolbox. That's a debate we have to have, because if it's not a backdoor, it's something else. It's not because we suddenly call a backdoor a toolbox, it's no longer a backdoor. Or how will this magic toolbox work? If computer scientists say it's not possible to make a backdoor or a toolbox that only works for one device, suddenly this toolbox apparently can still do it because we don't know what it is, so we can't discuss it, right? So, of course, we can guess what it is. And probably one of the things is 0 days. So for the less technical people, a 0 day is a flaw in a system, a bug that allows you to get access to the devices. And this is what police has been using, but also law enforcement, but also intelligence services. So what you do is you exploit the system and you hack the end system. So rather than trying to intercept communication, you just hack the end system, which gives actually much more intrusive access than you ever had before. Right? What's on your smartphone today, there was not a device in the past had all this data. Even if they searched your house, they could not find what was in your office. If they searched your office, they couldn't find what's in your house. So in fact, your whole life is in this smartphone and is accessible with this 0 day. So if you actually don't have the resources to develop 0 days, you can buy them from Hacking Team. Hacking Team is an Italian company that actually sells backdoors to law enforcement. How do I know? Hacking Team was hacked, and they lost all their data, including their 0 days, including their customer lists. You can read on the internet 47 gigabytes of data that shows you how law enforcement actually uses 0 days to undermine security. So of course there is major consequences for society if governments start doing this, because these 0 days will leak out eventually and will be used to attack our society, while our society becomes more and more dependent on technology. Will be used to hack cars. We have seen, of course, last year's WannaCry. WannaCry was based on a vulnerability obtained from the NSA by shadow brokers and leaked to criminals or used by North Korea. We don't know, but it was actually used to attack companies. And the answer I heard from a person I will not name was, well, the companies had 3 months to implement the patch, so they shouldn't whine that they were hit by WannaCry. But so this is collateral damage. The government invests in finding 0 days, doesn't warn companies and citizens on time, and then actually it's used to attack society. So it's getting so bad that Microsoft called last February for Digital Geneva Convention. The Convention of Geneva says that you should actually not attack civilians in wartime, you should not bomb hospitals and schools and so on. Well, in the digital world, we actually attack civilians in peacetime. This is the state of the art today, and by actually looking for 0 days, exploiting 0 days, and using those exploits, you risk that they actually get out in the wild and are used against civilians in peacetime. So this is not the academics, this is not the NGOs, even Microsoft complains about the fact that this approach with 0 days is going to bring society into trouble. So I think the main answer is, or the main problem is oversight. And it also was mentioned this morning. I think it would be very naive to think we can stop this 0-day business. It's going to happen. It's much more intrusive than a backdoor in communications. It's a backdoor in everything. This is, I think, what law enforcement will do and what intelligence is already doing anyway. This is the state of the art. I wish I could stop it. I'm afraid we can't. So I think if we then decide that in society we have police, law enforcement, intelligence using exploits, I think we need a much stronger supervision than we ever had. And not only by people with legal experience, also by technical experts who understand actually what the risks and implications are of the use of a specific backdoor. I'm going to stop here. Thank you very much for your attention.
Thank you, Bart, for such an interesting contribution. Thank you for also to remind us the hacking team case, where in addition to the position raised by the European Parliament in an important resolution, the EDPS too has adopted an opinion to focus on the point you mentioned. So thank you really for such a contribution. It's time to move now to Jay Stanley, Senior Policy Analyst with ECLU, where he deals with a specific project on speech privacy technology. You do a lot of researches, authors, and you have been also analyst before joining ECLU at the technology research firm Forrester. So in addition to the other interesting experiences, I think you may give an interesting contribution. Till now, we have been discussing about encryption here in Europe. But we know that in the US, the discussions about encryption have become hot as well, and particularly after each of the series of some criminal or terrorist incidents, as from the San Bernardino shooting, a case on which I've been asked by 4 national parliaments here in Europe and the European one to say a word. So we are all curious to see where does the discussion stand at this moment. And it would be interesting from your side to also better understand how we, as European, we may expect that the technical tools coming from US, much of the worst technical tools come from the US, may protect our rights as well as all those of the US citizen. Increasingly, I see from the different contributions that before approaching the fundamental rights dimension, this is not only a privacy versus a security issue, but is largely a security versus a security debate. So, but Jay, the floor is yours.
Thank you very much. So, the way that I view the encryption debates in the United States is that really this is part of an overarching historical process that we're seeing. I think there's typically a lag in society between when people lose their privacy and when they realize that they've lost their privacy. And in that gap, we often see privacy exploited. And the technology has been moving so quickly that that it has not been secure, and in that gap and in that lag, law enforcement has had a field day and had an unusual ability to intercept communications. But in the end, privacy always wins. People need privacy, they need security, and in the end, the gap begins to close over time as people realize how much privacy they've lost, how insecure their communications are, because in the end, people need privacy and cannot tolerate not having it. And so I think that we're in the process of a tug of war, seeing how encryption can be applied in different venues versus the authorities who want to preserve the special powers that they've always had. I want to talk about 5 areas where there has been debate in the United States about encryption, some of them well known, some of them quite obscure. And I think that, that's sort of, so that would provide an overview of where the conversation is there. The first one, obviously, is over backdoor proposals. This is the most high-profile one, and we have been hearing in Washington from sources on Capitol Hill and in the government that this debate may be renewing again, that there may be another forthcoming proposal for backdoor, requiring backdoors and encryptions. I agree with everything the previous speaker said about this, and that you cannot separate encryption and security any more than you can create a perpetual motion machine. You can't just wave your arms and say, please create me. I know you can solve this problem. And so that fight, the government is doomed to lose that fight, but nevertheless the fight goes on. The second issue, also very high profile, is over the Apple San Bernardino case that Giovanni mentioned, which was about the government's ability to use something called the All Writs Act to order Apple to do work in order to unencrypt a terrorist's phone that was locked. That fight, we did receive one positive ruling from a magistrate judge, but the legal status of that fight was unresolved because the FBI mooted it out and they said that they'd found another way to gain that data. A third area that really impacts people very, very personally, where encryption is being fought out right now, is with device border searches. Anytime you cross the border in the United States, the Customs, the Cbp, the Customs and Border Protection Agency, claims that it can not only take your device and look at it, but can require you to open up by revealing your password, or at least to open it up for them. And the ACLU and the EFF, we have litigation over this. We believe that the Constitution requires the government to get a warrant issued by a judge to search devices even at the border. Obviously, Customs has had a long historical record of, has long had the power to search people at the border to prevent the entry of contraband into a country. But when they search devices, it is not to search for contraband. What they are really trying to do is find out information about you. And so the long-standing rationales for the customs powers at the border do not apply the same way to digital devices. CBP just issued a new policy about digital device searches. They claim that they can do, and it does include some improvements. They say that they can do a basic search of your phone with no suspicion whatsoever. That means that they can take it, they can look at whatever is visible on your phone for however many hours they want to spend perusing through your phone. What they can't do is access anything in the cloud through your phone, and they can't do any kind of forensic device search that involves connecting another device, and that's how it's defined. But no warrant, no judge in the loop necessary for that. And for advanced searches where they do a forensic search, attach a device, download your data, et cetera, look for deleted information, they claim that that can be done merely with reasonable suspicion and no involvement of a judge. CBP claims that travelers are obligated to present electronic devices in a condition that allows them to be inspected. In other words, you have to open it. You don't have to tell them your password, but you have to open it. And notes that an officer may request assistance from the traveler in accessing the device's contents. Refusal, if you're an American citizen, means you may be detained for many hours, 6, 8 hours, And you may have your device confiscated for, I think the new policy is 10 days or 2 weeks. If you're not a US citizen, you can be refused admittance to the country. So, and you know, one interesting question about government officials accessing your device is raised by the Apple X, which of course has the Face ID, which uses your face biometric as a way to open up the phone. And one question is whether the CBP officer could take the phone, point it at your face, and thereby open it, even if you have decided that you don't want to do that for them. The fourth issue is, that I want to talk about, is forced password disclosure outside the context of the border. So if the police have obtained your phone and have a warrant to search it, which is always required outside of the, we argue, on the border as well, but is certainly under established Supreme Court law, always required inside the border, can you be forced to give the police your password to unencrypt your phone? So the law is kind of unclear in this area. We have the Fifth Amendment in the United States, which is a prohibition on being forced to testify against yourself or incriminate oneself. The classic example here is, in how that's been interpreted, is that you can be legally required to turn over the key to a safe that has evidence in it, but you cannot be forced to disclose the combination of the safe, because that is in your mind, and it's testimonial. It's testimony that could be used to incriminate yourself as opposed to a production. But how that applies here is very, very murky and still unclear in US law. One court case found that you cannot be forced to give up a passcode to get into your phone, but you can be forced to provide a fingerprint, because the fingerprint is like the key and the passcode is like the combination in the lock. That's one court case. It's not clear whether that will become prominent law, and there are some legal findings that cut against that. What is true is that the more the government knows about what's on your device, because of the way that the Fifth Amendment doctrine works, the stronger its claim is to be able to force you to produce it. If it knows of a document and knows you have the document, they'll have a much stronger claim than if they're merely on a fishing expedition trying to find out what's in your phone. And the ACLU and EFF in court have argued that forcing an individual to decrypt data, to go through the mathematical process of unencrypting it, is inherently testimonial. It's always testimonial. One last interesting issue that I want to mention that we're starting to see raise a little bit in the United States is involves the use of encrypted messaging apps like Signal, which are end-to-end encrypted. And that's becoming more prevalent in politics, especially in the wake of hacking of Hillary Clinton's campaign and the Democratic National Committee. Many more politicians are using these encrypted apps, which of course goes back to reinforce how security and privacy can't be separated. But this collides with open records laws, laws requiring government decision makers to keep records of their communications, et cetera, so that there can be public disclosure. White House staffers were reportedly running around using Confide, which is again another encrypted app, to keep their communications secret, until former White House Press Secretary Sean Spicer actually ordered them not to use that, saying that it was a violation of the Presidential Records Act, which is one of our Open Records Information Acts. So that is sort of some of the prominent ways in which encryption is being fought out in the United States right now, where we're seeing these conflicts arise. I think we'll see many more. I think in the end, encryption will win in most cases. Obviously, some of these legal things are undecided, but encryption will become more and more prominent, and these efforts to fight the tides here will fail. And I look forward to a good discussion about the rest of the issues. Thank you.
Thank you, Jay, for broadening the analysis. Indeed, encryption is just one of the issues to be considered. 25 minutes to go. I'm afraid we will have less space for questions, but presentations are really interesting, so I'm not going to depress anybody else. Now it's time to move to Graham Wilmot, and we know that after having worked as a nuclear engineer on various UK nuclear power stations, he joined the European Commission to develop assistance programs to nuclear regulatory authorities in many countries, particularly in Central and Eastern Europe. And you contributed to the work which led to adoption of the REACH regulation in 2006. But you're currently, as from October 2016, here being the head of the unit for cybercrime in DG Home. And we know that the unit has responsibilities including the policy on all aspects of cybercrime, illegal content, and child sexual exploitation. Graham, the floor is yours.
Thanks, Giovanni. Good afternoon, everybody. Several of the previous speakers, and indeed Giovanni, have mentioned the importance that the Commission attaches to strong encryption. We do. I'm not going to repeat that. But at the same time, encryption presents a problem for law enforcement authorities. Now, Bart quite rightly asked, who the hell are law enforcement anyway? For the purposes of my intervention, law enforcement are member state law enforcement authorities, one of the 28 member states. Not intelligence, that's outside the scope of the EU treaties, certainly not something I'm going to speak about here. So I'm going to talk about the problems for ordinary policemen and also for prosecutors that encryption can present and what we can do about it. The other thing I want to say about the framework of my speech is I'm talking about regular criminal investigations and evidence obtained in accordance with practice in any investigation. There'll be a warrant or a court order for the police to have access to the relevant evidence. Then they find it's encrypted. Fine. What do they do? At the end of 2016, the member states, through the Council, asked the Commission to have a look at this and see what we could do to address the issue. Well, what can the Commission bring to the party, apart from a series of retired nuclear engineers? Usually at this stage I say something about the guardian of the treaties, the European interest, and so on. That's all true, but actually we can also bring another gift, which is tedium. This is a really exciting subject. There's lots of interesting technical details, serious fundamental rights, serious legal issues. How on earth do we address all of those, bring them together, and come up with a suitable compromise, if I can use the C word that you mentioned earlier? We do this by setting up a process where we talk to all of the relevant stakeholders. So, of course, we talk to law enforcement, we talk to cybersecurity experts, because, as you said before, it's a security versus security issue. We talk to Eurojust, we talk to the Fundamental Rights Agency, we talk to industry, both the security industry and the various kinds of service providers, and to academia and to civil society organisations, NGOs if you prefer. We spent the first half of 2017 in a long series of workshops and discussions with these poor people. We locked them in rooms with men in grey suits like me, and we talked endlessly about the issues. And sure enough, after about 6 months of this, many of them had lost the will to live, and we were able to agree about what are the key issues underpinning this. I'm not saying they all agreed on what the solution should be, but we had a good grip on what the key issues are, and we'd taken a lot of the heat out of the discussions. The assessment that we came to, I'm not going to blame the stakeholders for this, around the middle of last year, is that there is a real issue. There is a need to act. We're seeing investigations that are not being pursued because evidence can't be decrypted by law enforcement. We're seeing prosecutions that are being dropped because judges don't believe that the evidence can be decrypted and used in a court case. This is true for a wide variety of crimes, not pure cybercrime, but also for, how shall I put it, regular crimes that involve digital evidence. What also came out of our discussions was a recognition that there's an issue here about the rights of the victims, the rights of society to expect that crimes can be properly investigated and that perpetrators can be brought to justice and convicted where the evidence is there. And of course, once again, this requires all of the normal safeguards, such as court warrants, notification systems, and proper handling of the chain of evidence. But at the same time, we fully stand behind the need for secure internet communication, and that means strong encryption. So how are we going to square the circle? In September last year, we published a communication setting out a series of actions. And I obviously failed in my goal to make it quite as boring as I wanted, because some people found some of the elements a little bit exciting. I'll go through the elements and I'll clear up, I hope, some of the misunderstandings, some of which I must take the blame for. There are 6 main elements in the communication. The first is to strengthen Europol's technical capabilities to deal with encryption. The second is to set up a network of centres of expertise of law enforcement in dealing with encryption. The third, to create a toolbox of best practices to deal with encryption. The fourth, to set up a structured dialogue with industry and also with civil society organisations to talk about how encryption impacts on law enforcement investigations. Fifth, a training programme for law enforcement and for the judiciary. And finally, to establish an observatory for legal and technical developments in this area. I should say we are not going to propose any legislation that directly deals with encryption. In your introduction, Giovanni, you mentioned that we'd be proposing something to deal with encrypted evidence. That is true, and also not quite true. We're looking at coming forward with a proposal in the coming months on e-evidence, how to get access to evidence across borders. That proposal will deal even-handedly with encrypted or unencrypted evidence. It won't deal with the issue of, if you get hold of the evidence, can you, as a policeman or a prosecutor, read it? So it would be strictly the cross-border access to the evidence, blind to encryption or non-encryption. Anyway, turning to the actions. First of all, none of them is going to limit encryption, weaken encryption, or introduce backdoors. Let's look at the first one, the strengthening Europol's capability to deal with encryption. A couple of days ago, Wednesday of this week, we came forward and said we're going to give 5 million euros to Europol's budget to strengthen their capability here. What they're actually going to do with that is to enhance an existing capability. That is, when a member state law enforcement agency has a device that it's obtained in a criminal investigation in accordance with a warrant or whatever, and it can't read it, Europol has an intelligent password guessing capability. That allows it to make, obviously, intelligent guesses rather than purely brute force, guesses on what the password of the device should be, and then enable the law enforcement to unlock the device and then obtain whatever evidence the court order entitles them to obtain from that device. The money is for that technical capability. It's not to get extra staff, and here comes my mea culpa. In the communication last autumn, there's a mention of 96 staff. In fact, it's not 96 staff for encryption, it's not 6 staff for encryption, it's 0 staff for encryption. It's not one of our happiest pieces of drafting. I will take the blame for that. It's purely money for the technical capability, no extra staff. The next item of the 6 was this network. Kind of explains itself. When we first started our process of discussion early last year, Europol brought together the experts who talked about what would be useful, what they were doing. But in the coffee breaks, Europol said the feedback was, gosh, this is really useful. This is the first time I've ever spoken to people like me. So it's really a network for these experts to share their experiences, share best practices. And we've seen that some member states are much less advanced than other member states. And this is, we hope, an easy win to bring some of the weaker capabilities up towards the capabilities of the stronger member states. Next, the toolbox, which is another area where there have been some strong reactions. This is about sharing between member states the best capability, the best practices that they have. I would expect that this is going to start with some rather simple and frankly dull but useful advice. Things like when you, during an investigation, enter premises and there's a device that might be relevant, if it's plugged in, don't unplug it. If it's unlocked, don't let it time out and lock. Banal stuff like that sounds obvious to all of you, it may sound obvious to me, but if you're a policeman who doesn't work in this area, it might be useful advice for you to have when you go in. It's the kind of advice, the kind of training that sometimes Europol refers to as Tier 1, the basic stuff, avoiding mistakes during investigations. We'll have to see where the toolbox goes over time. It may grow, but of course it will be a question of building confidence between member state law enforcement authorities. The next point that we looked at is the structured dialogue with industry and with CSOs. I like to think of it as projecting TDM into the future. There tends to be a lot of mistrust between industry, CSOs, and policymakers. I think if we sit down and discuss regularly what the issues are, what our concerns are, what we're trying to achieve, usually over time, after the heat dissipates and mistrust disappears, we can find small, practical steps that help us to advance the interests of law enforcement without challenging the interests of industry or of privacy. Usually it's very small, very practical steps that come out of this kind of thing. Training, the fifth point, rather speaks for itself. We'll work with Europol to identify needs. We have a group of experts to develop the content of relevant training courses, and CPOL, the Police Training College, would deliver the training. We're looking at a framework for that and funding for that. Last but not least is the observatory. Typically, police and prosecutors are playing catch-up in this area. Technical developments go fast, legal developments sometimes go quite fast as well. What we want to do is have a function in Europol and perhaps in Eurojust to look at what's coming down the road, give us a heads up, maybe annually, so that we as policymakers can see what's coming and try, if not to get ahead of the game, at least be level with the game for once. EDPS, we know, has taken an interest in this. We'll be happy to continue discussions with EDPS and indeed all of the other stakeholders on this. Now, these 6 steps are worthy, I think, but not exactly world-shattering. So we're going to continue our reflections on what we can do in the area of encryption and see if we can identify further steps in future. But certainly with the 6, we have our hands full for the next few months at least. Thanks for your attention.
Thank you, Graham, for such a substantive overview. As EDPS, we share most of the views with other data protection authorities, and this is the message I passed to Commissioner King. I met him twice by focusing on what we can do now. You mentioned Europol many times, and my mind goes back to a statement Europol has issued together with ENISA, where encryption is still recognized as a valid tool to secure communications. Your contribution is also linked to the first one by Xavier, and therefore to the effect that this debate on decrypting may have on alternative means of investigation. And my mind goes to my country of origin, where the government has passed in the last few days a legislative decree focusing on the Trojan horses. And there is a huge debate now on the issues of proportionality and necessity. But you also allow me to go back to one important piece of legislation, which is sometimes ignored by authors. I'm referring to the Budapest Convention, which is to be applied not only to computer-related crimes, but to also every kind of collection of evidence online or with regard to software, hardware devices. And as a result of cooperation with data protection authorities, 2 articles of the Budapest Convention provide for strict necessity and proportionality, global. And of course, this also relates to the collection of evidence via decryption. Gail, is now your time. We depart from the principle ladies first to allow you, to now build on a basis of previous contributions. You have a lot of responsibility for global cybersecurity surveillance and law enforcement policy within Facebook. But I think your experience is particularly relevant because before joining Facebook 3 years ago, you have been serving the UK law enforcement for, is it okay, 17 years? So I think your career developed with many interesting, let's say, law enforcement bodies, including Interpol. You had an experience in my country of origin as well. So what else? I think you are in the best position to lead us to the conclusions of this panel.
Thank you, Giovanni. And I don't mind it not being ladies first. It's always great as a woman to get the last word. And I'm also, it's also great to be here at the Caspar Bowden lecture because the first conversation, I think some of the first conversations I had about encryption were back in 1998 when I just joined law enforcement, and Caspar was like a dog with a bone, and he was really concerned about trust at that time. And I'm going to start with trust and finish with trust. Caspar was concerned about his ability to trust the government that he felt at the time was not sticking to its promises on requesting cryptographic keys. And he was also really, really concerned about the trust that we could continue to have in technology. So I don't know if it's good or bad to be here almost 20 years later, or exactly 20 years later, and to be having some of the same conversations. But I'm going to talk a bit about what this looks like from the Facebook group of companies perspective, and that obviously includes WhatsApp, which is usually where our conversations about encryption start and finish. And I completely agree with what a lot of I suppose one thing to point out is this is a really, really real debate for us, whether that is some of the issues that Jay's talked about at borders, and it's not just the US border where there are allegations about people taking devices and gaining access to them, but it's also of concern to us in countries like Brazil, which I've just come back from, where WhatsApp gets blocked because it's not providing content that as a company we don't have, we don't store, we don't see ourselves, but yet we are being penalized for the fact that we are using end-to-end encryption. But it very much is a balance of security against security, and it's often that balance that pits governments against companies. So I'm sure the data protection experts amongst you will be happy to know that as a company that is the steward of data for over 2 billion people, that keeping that data secure, particularly in an age where every day we are seeing headlines about cybersecurity attacks and hacks, is really important to us. It's not just important to us from a Facebook perspective, it's also important to us from WhatsApp, where we know that it matters to our users. And encryption to our users is not just sort of like a technical thing that doesn't matter. It really matters to people, whether they are activists sharing information, whether they are the sort of government officials that previous speakers have talked to, or whether they are just normal everyday users who believe that WhatsApp, because of the level of security, enables them to have conversations that they perhaps would be less comfortable having on other devices. And yet you have governments that are absolutely, and I completely understand this from my previous background, concerned about security that is connected to terrorism or child sexual exploitation, so security online. So you absolutely have that clash. But interestingly, I think now we're getting into a level of discussion where you are seeing that slightly more complicated. So companies like Facebook and WhatsApp are correctly being held to account for what our responses are to things like Facebook and things like terrorism and child sexual exploitation. But you also see governments, and Jay just talked about the US government. You see governments and politicians around the world also using secure technology to help further their business. So it's getting a bit more of a complicated discussion. And I think that complex discussion really needs to have a complex response to it. And we were particularly grateful to the Commission in the work that they were doing, that they were being thoughtful, they were talking to all of us and trying to take into account some of the complexities. And I want to highlight 5 things that we think that needs to be taken into account when looking at the response to the encryption conundrum. The first thing is the fact that we need to be dealing with technology and the law, and realizing that it's not just technology, it's also the law that is preventing access to data. And when I talk about technology, I think we also need to, and this is coming up, I think, increasingly in debates around the world, we need to understand that encryption is not just a one-size-fits-all. We're talking about very different problems that come with different types of encryption. So Apple versus the FBI, full device encryption is a different sort of issue for governments than end-to-end encryption, than just over-the-wire encryption is. And I think we need to be more sophisticated in what responses to those 3 different types are, and we need governments to be explicit about the problems that they are experiencing with the different types of encryption that they're coming across. But we also, as I said, need to acknowledge that access to content and to data that companies have is not just about encryption, it's also about the law, which is why we're also very happy that that the unit that Graham's in hasn't just looked at encryption. It is, as Giovanni mentioned, also looking at the e-evidence debate and what changes can be made to laws around the world that prevent access to data, that will help companies like Facebook in legitimate investigations where there are clear human rights standards and provide content where that's going to help resolve a serious crime. So acknowledging the law is the first thing. The second thing that I think we need to acknowledge in any response is that you can absolutely not have a national solution to this. Any solution has to be international. We know when there have been debates in the US about banning certain types of devices or banning end-to-end encryption, that's not really going to work. And I think previous speakers have nodded to this and the fact that if you ban encryption in one country, whether it's device or end-to-end, that doesn't stop somebody just nipping across the border and getting a different type of device or installing an app that's not banned and isn't adhering to any national ban. And again, that's a point that we make repeatedly, not just in discussions that we've had here in Europe, but also in discussions in Brazil and India, where it's a very live debate, and also in the US. Thirdly, when looking at what our response should be, I think we need to be thinking short and long term. And this is somewhere where I think that we haven't focused enough as a community. Anything that impacts on encryption now is going to have a long-term impact on our security. Some of the great cryptographers that we work have likened our current state of encryption as like the Wright brothers. We're really nowhere near being able to build a Boeing 747. We have very, very basic encryption when we look at the sort of encryption that they're wanting to build. And I think that's clearly understood when we look at breaches that take place and the fact that we still aren't able to properly secure, and I mean us collectively, secure our data in a way that we would ideally want to. So why would we do anything that's going to stop innovation and development of encryption? Why would we do anything that would try and put the encryption that we have now in aspect? And then finally, I think we also need to approach this debate with transparency. And again, I'm grateful that the Commission, this was one of the things that they very much tried to do. So what is it exactly that law enforcement can do nowadays? What data can they get access to? What data do they need to get access to? Because I absolutely understand what it's like as a law enforcement professional to want to gain access to everything, but what is it that you actually need to deal with the current investigation? And one thing that I find like personally disappointing when I'm looking at surveillance legislation around the world and changes in surveillance legislation is I can't tell you of a single instance where that legislation has been accompanied by a strategy for getting policing up to a level of digital skills that Graham has just highlighted, just doesn't exist. And we need to be at the point where every single police officer understands what they can and cannot get and how they go about getting that. And I understand how difficult that is. When I first sort of started policing, the worst thing I had to worry about was a different pattern of telephone kiosks that was being used. I didn't need to work out whether somebody was using an iPhone or an Android, and whether which of the 6 devices they were likely to be communicating on with which app. I understand the complexity, but we need to get better at training law enforcement so they understand exactly what they need. And then finally, I said I'd come back to trust. We cannot have this debate unless we understand that fundamental to the internet and to technology is being able to trust that technology. You can all imagine what it would be like if WhatsApp really wasn't end-to-end encrypted, if we were just saying that. The level of trust would absolutely disappear overnight. And our ability to provide technology is only is reliant on the fact that we provide the technology that we say we do. But again, I'm really grateful for being here, and it's fantastic to be part of a Caspar Bowden panel. Thank you.
Thank you, Gail, in particular for focusing on two essential comments on trust, transparency, in addition to fairness. We have time for one, perhaps 2 burning questions. Very short. Someone interested from the audience to act as icebreaker? 30 seconds first. Please.
Tobias Morsches from Datenschutzraum, Germany. My question is this lag you told of between privacy and the development of technology, is this responsible for this discussion? Because in the real world, we cannot say we get a court order for something that someone that was not suspected has said a month ago. So we can only do for future. And for me, it's like what is encrypted. I cannot give a warrant to decrypt it if I have not had him under surveillance before. So.
Yeah, I mean, I think in many ways, the advent of encryption represents a return to the types of conversations that people always had throughout history that were not subject to interception, to people talking out in the middle of a field or in a street in a village. We were never certainly retroactively able to be, intercepted and not real time. And so I do think that the lag that I talked about is one of the reasons that we have such an intense conflict here, because law enforcement got used to that, to enjoying that gap between people's understanding of the degree to which they were subject to surveillance and the actual amount that they were subject to it, and has intensified law enforcement's sense of loss over the arrival of encryption.
One more.
Ian Brown, a very specific question for Bart and Gail. Bart, you mentioned briefly the idea, which you often hear floated in policy circles these days, of the sort of, the adding the policeman or the intelligence officer as another member of the group without notifying the user as a way to do very specifically real-time intercept. I must admit myself, despite being encryption obsessive, I think I've only verified one person actually on WhatsApp or Signal. It's certainly not something that the current user interfaces make easy, and it would be fascinating to know what percentage globally of those links were actually verified. Could you see that as a meaningful compromise in future? And Gail, the difficult question for you then is that governments often say, well, we're having these ongoing conversations with industry, we're not going to say build backdoors in or blah, blah, we just want you to do things like don't have end-to-end encryption as the default, for example. I know it's a tricky question, but how do you think Facebook or other industry would react to suggestions that, okay, governments are moving to this model of adding the intercept as a friend, and by the way, please, industry, do not make end-to-end authentication any easier?
I was actually not really serious. I was more joking, but of course, maybe it's good to point out that some recent research has pointed out some flaws in the Signal and I guess also in WhatsApp, then where apparently third parties can join a conversation without some of the other parties not being notified. And this is seen as a flaw which should be fixed, because obviously we don't want this if we have a private conversation. I was just jokingly saying, if it's technically possible, because we can do it, of course we can do it, but we see it as a flaw, and of course the question is not, can the police join? The question is, if the police can join, who else can join? And I think this is where we say we don't have an answer, so we should not have this kind of flaw.
And I think that I can just build on that. WhatsApp is constantly being reverse engineered, so anything that is seen as a flaw or a likely backdoor is going to be spotted quickly. And then Ian, to sort of like really explicitly answer your question, for us it comes back to trust and transparency. We have to be absolutely clear to our users the service that we provide. And we provide end-to-end encryption, and you can verify the people that you're in a group with, you can verify the people that you are talking to. We are not going to be adding secret people into groups as a way, because for us that is undermining the trust in the service that people have.
Ladies and gentlemen, I'm the worst moderator that you have seen in the past 3 days. But sometimes I think I like the flow of information, and it's rare to have the information we gathered today. What I sense is that it's not always the same. There are new elements, both on the level of policy making. 5 million euro in Europe, that's a lot. Graham, we will look at how you spend it, and we hope you come back next year explaining us how it is spent, and because we're interested, and I want to have a part, by the way. And also on the level of the applications, the battles of encryption, what I took from this, especially the beautiful analysis of the several battlefronts with regard to encryption. And I think, ladies and gentlemen, that we will have to do it with this, because the time is up, and we have learned a lot, and we will have to ask our questions next year or so, or afterwards when we have the cocktail. So I would like a round of applause for this beautiful panel, and